hello, everyone. Now, if you're a founder, most of the time you spend building products, testing things, getting out, talking to users, all is well. And occasionally things go wrong. There are founder fallouts, there are supplier disputes, there are employee problems, the stuff you didn't want in your life. Now, hopefully you've done your agreements on SeedLegals or with a lawyer. And when there's a problem, you look in the legal agreement and it'll tell you what to do. But sometimes there isn't a legal agreement, or sometimes it's not clear, or sometimes you don't agree with it. And then, is it pistols at dawn? Is it have to hire a lawyer? Is it going to get expensive? Well, there is an interesting alternative, which is dispute resolution, mediation, arbitration. And to talk about all of that and what to do when things go wrong, we're here to talk with Iain from Pinq Dr. Now, Iain's a barrister, now doing a startup, I guess the SeedLegals of dispute resolution. Iain, tell us a bit about yourself, and then over to you.
Yeah, sure. Hello. So I'm a barrister, as you say. I've been a barrister for 20 years. I do corporate disputes, company disputes across the sort of full range. And I'm also the CEO of Pinq Dr, which is a startup online dispute resolution platform, which provides binding resolution of disputes in 6 to 8 weeks, which is drastically different to the way that things currently operate.
Okay, so thank you. Now, let's start with, before we jump into an example, let's start with the concept, which is, so you've got a contract, hopefully, something has gone wrong. You would normally think as the first port of call is to call a lawyer and end up in court. So take us through, maybe we'll jump to an actual example. The most common one we see at SeedLegals, unfortunately, are founder fallouts. So maybe 10 or 20% of the time, there is, people get together in a pub, have an idea, are the best friends, sometimes have a founder agreement, sometimes not, and a little while later it turns out they can't see eye to eye, or somebody has to pay the bills and needs a proper job, and wants to leave. And now there's a dispute over the number of shares. Sometimes they haven't set up vesting. Sometimes the departing founder just has all their shares vested, or doesn't have a vesting agreement, but the number of shares they've got exceeds the number that make the company investable in the future. So they've got 30% of the equity. No one's going to invest in a business that's got a departed founder with 30%. And they now want to sort out, in the best case, they reach an amicable agreement, which is great. But let's say they can't. So take us through what options they've got and how dispute resolution, in both the sort of negotiating friendly way and the legal way, will help.
Yeah, sure. So the amicable kind of solution, as you say, always the best way. Always better to try and resolve these things between you in a kind of commercial discussion. Of course, that doesn't always work. So then, step number one is look at what you have agreed. So if you're a founder, you might have agreed a founder's agreement, such as the one that SeedLegals has. If you've had subsequent investment, you might have service agreements, you might have a shareholders agreement or a subscription agreement. Really important to check those and work out what they say, because they may well deal with the situation that you find yourself in. There may well be provisions that deal with how you resolve that kind of dispute.
Can I hop in quickly? So
yeah.
For those not familiar, and I don't claim to be an expert in any way, agreement in the UK is fairly broad, which includes a handshake in a pub, through to a deed and a binding thing. So take us through what sort of evidence might somebody have. So if you've got a signed agreement and you've had a verbal discussion that is different to that, or if you don't have a signed agreement, what things might, because when you have a dispute, when people are friends, all is well, you just agree. But when you're not friends anymore, you're going to look for every little bit of evidence to go, actually, you promised me 20%, but this agreement says 10%, but I'm actually going to hang on to the 20%. So take us through what an agreement could include.
Yeah, sure. So agreements, there's a sliding scale, effectively, at the top level. And the best kind of agreement that you want, and as a startup, as a founder, the type of agreements you should be looking to put in, if you can think about it, are signed written contracts with a dispute resolution clause that set out your provisions and in a kind of nice form that you then retain. That's the kind of gold standard. Always much easier to have that kind of document because you can point to it and no one can say, oh, that never happened. But as you say, as a matter of English law and indeed most common laws around the world and also some civil law countries, i.e. European countries, you don't need to have a signed written document. So you might have a document that came into existence that wasn't actually signed, but was exchanged between you. So that's sort of the next level down. So let's say you and I, Anthony, exchanged some emails where I said, this is how things are going to happen going forwards. Do you agree? And you reply, yes, I agree. Next level down is I send an email and I say, this is how things are going to operate between us, and you don't reply. Now, I might say later, hang on, well, you didn't reply. That means you agreed to it, and I rely on that. Next level down is, well, we have a discussion and we say, look, things are all going swimmingly now, but in the future, we want X and Y to happen. And if we have a fallout, this is how things should play out. And we both say, yes, absolutely, that's fine. Very often, that kind of verbal agreement, there is no record of it. And you always want to avoid being in the situation where you're relying on an oral contract. It can be an oral contract, but to prove that contract, often it'd be my word against yours. We're in the pub, you say, I didn't agree to that at all, or you say we were having a drink and it was, we weren't intending to create a contract at all. You don't want to be anywhere near that. And particularly bearing in mind just how long, expensive, difficult legal proceedings can be. What you don't want is to have the added difficulty of trying to make out that there was ever an agreement between you in the first place.
Okay, so I mean, it could also be a WhatsApp thread as long as one of us doesn't lose our phone over a ship in the North Sea and lose our WhatsApp thread. So now, what happens if the discussion doesn't align with the agreement? So you can have in the agreement that it says this is the complete agreement and it replaces and supersedes any prior discussions. Talk about, that you've been discussing a range of things, right? I want 30%. No, you get 20%. And now we've got a range of possible things and an agreement that says something different. How do people know which is the definitive one?
Yeah. So the definitive version, i.e. the signed version, will almost always be the version that binds everybody. That's not always the case, but it's normally the case. Sometimes at a later stage, someone might want to say, oh, actually, you sent me that document. Yes, I signed it, but I didn't read it very well. And in fact, we'd had a discussion before where you told me something different. In fact, I was doing a case about that very recently. And there are legal routes in which you can say you can't now rely on the contents of that agreement. There's estoppel arguments and things like that. So there are methods in which you can try and say, hang on, we agreed something different to what's in that signed document. But generally speaking, that will be incredibly hard. So if you have a signed document, almost all cases, that's what will govern your relationship.
Okay, all right. So let's say you've got your signed document and you've got a dispute. What are your next steps as the founder in this case?
Yeah, so have a look at those documents. They might, as I say, look, if there's a dispute between the founders, then it's resolved in the following way. It might also say that the direction of the company or decisions about how founders should leave and on what terms are resolved in the following way. Obviously, that then answers it, and you can follow that route. If there are disputes about that, well, then you then get to what you do about a legal dispute and whether you go to court or not, which is a different question. For now, though, let's assume that the contract doesn't deal with it, and actually, that's not unusual. It's quite difficult to provide in advance for every situation how things are going to pan out. It's also difficult to provide for a situation where, let's say, you have two founders, each of whom have 50% of the equity, 50% of the voting rights. There aren't going to be provisions that say, well, I can throw you out or I can reduce your equity so that the company retains, so you retain only 10% and then I can get outside investment. And so then you are and can find yourself in that situation very often at a stalemate. Basically, you can't do anything. The company, you are stuck. Now, your options then are One, to try and get some sort of external assistance with trying to resolve your dispute. The thing that people underuse, in my experience, in this type of dispute is something called mediation. Mediation is an external person who will come in and give a view on the case, a non-binding view on the case, but listen to both parties. That can be really effective in trying to resolve a dispute because it takes the emotion out of the two founders. So that's always something to think about. The other is then ultimately is that you end up in court, and one of you are saying either that your position as a shareholder is being prejudiced or various other legal remedies, and you're seeking a legal remedy from the court. But in the type of situation we're talking about, a court-based remedy, i.e., actually going to court and seeking some kind of resolution from the court, is very unlikely to be a proper solution for you.
Is it unlikely to be a proper solution? I mean, it's expensive, but it will not lead to the outcome that you wanted, or lead to a random outcome, or the judge will go, I don't have the solution here, figure it out yourselves.
All and any of the above. So number one, most of the agreements that we're talking about, if we're dealing with UK parties as well, will probably have an English court jurisdiction clause. That's usually the standard. For this type of case, to get to court, we're talking a year and a half before it actually gets to a decision.
Right. So the company's basically dead by then because it can't raise investment because you're in the middle of a dispute and no investor's going to invest. So that's kind of terminal already. Okay.
Exactly. So just because the time that it takes is just makes it's just never a solution for that reason. Even if it were, the cost of it, companies that we're talking about, these are expensive proceedings, and most companies and founders don't want to be spending that sort of money on these sort of proceedings. The third is that litigation in a court, given the length of the set of proceedings, is just really uncertain. You can get advice, and you can get, as a barrister, you can give advice, but ultimately, even in the strongest case, most barristers won't give a prospects of success greater than about 65 or 70%, because you can't deal for all of the things that might happen. So a document turns up, a witness just says something unusual in court, and that kind of uncertainty is just amplified by the time that it takes to get to court. And so, as I say, in all practical respects, this type of dispute is not going to find its solution through the courts.
Okay, so the first step that I always see is to actually look at the agreements that you have signed, because often they contain quite a few things that are surprising to one or both parties. So I had somebody come to me actually a couple of days ago with the founder fallout situation. I always brief my team at SeedLegals, if you've got that, send them my way. This person's last round was not on SeedLegals, so it wasn't our legal documents. So for me, it's an interesting intellectual exercise to see, as I look at the needle in the haystack, to see what will come out when looking at the documents. And I'll be clear, I'm not offering legal advice. This is sort of founder to founder advice. But the first problem that at SeedLegals we have is our client or customer is the company. But when there's a founder fallout, sometimes it's not clear who the company is. Certainly if it's 50-50, then we have to say, sorry, we can't help you at all, because you have to figure out which of you is still the company, and then we can help them. If it's, the two directors and one's left and the disputes, then it becomes clearer. So in this particular example, which was interesting, and I'm mentioning this because the first thing you should do if you have a dispute is go look in detail at the relevant agreements. And you might look at it yourself, as a first pass, to have a basic overview of where to look next, and you might want to engage a lawyer to do it. But in this particular case, when there's a founder fallout and somebody's a leaver, often the legal agreements will say that the departing person's shares become non-voting shares and they lose any director position and so on. So if the person's designated as a leaver, the fact that they had 25% equity and could have blocked votes and so on is now sort of resolved because they have non-voting shares, which is fantastic. So always take a look. And another really interesting one to look at is if there is a founder dispute, it may well go to the board, and the board could then fire somebody. But can you, if you're a director, represent yourself on the board And actually, under the Companies Act, and Iain, you're the barrister, but in the model articles, in Article 18, if I recall correctly, it says that a conflicted director cannot represent themselves on the board, which is really, really bad. So when you do a funding round, the BVCA articles, or the articles created, sorry, shareholders agreement, and articles created on SeedLegals, or the BVCA ones, will have a message wording to say Article 18 of the model articles does not apply, and you can represent yourself on the board. So it's those little nuances which are super important, that you need to do your homework to find out, if you are the, conflicted party, what rights you really have, because that will also determine your next steps. Okay, so let's go to mediation. So mediation is kind of like therapy, right? Which is, it's non-binding. You're going to go to somebody, you're going to be there in person. Tell us how it works, how much it costs. And by the way, can you do this on Pinq Dr in a new kind of way?
Yes, is the short answer to that latter part. Is it therapy? I think most mediators actually would say that is not the best way to approach it. I mean, certainly when you're dealing with founder disputes, obviously they're very emotive. They might be friends. They might have been together, known each other for a very long time. Both put investment into the company. Their friends and family on both sides might be involved. Incredibly emotional for all sorts of reasons. And whilst it might be, you might be looking for someone to give therapy, actually, the best way to resolve any kind of dispute, any dispute, doesn't matter if it's a founder dispute or something else, is to completely take out that emotion and look at the dispute in a really dispassionate, principled way. The best kind of example of that, I did a case for an investment banker against this bank, and he saw it as a trade. He saw this. Look, this is how much it's going to cost. This is how much I might recover. This is the time it's going to take me. And you work it in a very principled way. And the same should apply to every single dispute. And so going into a mediation, actually, the best way is to think, right, what is it that I want? What is the outcome that I am after? What are my parameters, and where am I willing to move? And the best kind of mediator will find that center ground where each side is willing to move, albeit they're not willing to say that outwardly, because it feels like you're giving up something. And that's the best kind of mediation. And ideally, both parties then come away thinking, I'm not quite happy with that, but I'll make do. And that's the best kind of outcome. Just the mediation process can either be an in-person process where you have a third party and that person shuttles between two rooms and says, look, the other side say this, you say that. How about this as a solution? Or you can do all of this online, in exactly the same way as we're doing now. You have breakout rooms and the mediator in a separate position. He shuttles between you. It's all done virtually, which is much more convenient these days. That can be really effective, particularly where you've got the type of situation we're talking about, where both parties are stuck. It's not like one party can say, well, I'm happy to just kind of sit where we are with this unhappy situation. It doesn't suit anybody. Everybody wants a solution. And so mediation can be really effective there.
All right. And how long does it take? How much does it cost typically?
Mediation doesn't take long. It shouldn't cost a lot. Really, the cost is simply the time of the mediator. That obviously depends on the person that's involved, but it shouldn't really cost very much money at all. In terms of timing, what normally happens is that there's an exchange of what's called position papers. You say, this is why I'm right. I say why I'm right. And then we have a few hours, or perhaps even up to a day, with a mediator doing that shuttle position.
Okay.
Now, that mediation process, you can, once the dispute has arisen, then elect for it. You can say, look, Anthony, we've got this, we've fallen out. I think we should go and have this resolved if we can with a mediator, and that's fine, we can agree. Difficulty of doing it at that stage is that often if I propose something, you'll disagree, because by that stage we've fallen out, and it's much more difficult for parties to agree. And so going back to the contract, and this really goes back to right at the outset of the relationship, if you can, think about what goes in those final few clauses of the contract that no one ever looks at. There's always a jurisdiction clause, typically in the contracts we're talking about, that says English court. Think about that clause. And I would encourage people to say, actually, first step, go to mediation. Second step, find a quick binding solution, not one that actually then provides you a real solution in a good time, not one that takes a year and a half through the courts. Because for this type of dispute, that's just never going to work.
Okay, so I always think of legal contracts like the manual in your car. You're driving in the countryside, the car breaks down, you open the manual and you hope it has a solution. And I get personally pained when I see, founders looking in an agreement of ours and it not having the solution to that particular problem. And the most common, contentious issue is definitely founder fallouts. And so there, actually, since we met and had this discussion, I want to see, can we add in SeedLegals? I need to look at those provisions to add an option when you create the agreements to say, I'd like a mediation and or arbitration. So let's jump in further with an example. And the usual example, and we'll cover, vendor and supplier disputes and so on in a few minutes, but the usual one is something like there's a founder fallout, the founder's shares, let's say everything is beautifully covered legally. The founder had 30% equity, they've been there for a year, it's vested over 3 years, or let's say they've been there for 2 years, so they now have got 20% equity. But 20% equity, they're going to investors in a new round, and the investors are saying you have to get rid of this existing founder or reduce their equity because we're not going to invest if there's 20% of non-working equity. So they now want to reduce it. The problem is the founder who's got some equity has gone, I put years of my life into this, you can't just remove it, take it away. So one of the things that I remind people is there's always the nuclear option. And the nuclear option, which people often actually suggest, is I'm just going to shut down this company and make a new company. And I explain that nuclear options, the whole point of a nuclear option is to have the option, but not actually use it. Because shutting a company and making a new one comes with no end of trouble, anywhere from SEIS and EIS to, the founder that now has nothing and sees you starting the new company might look in the agreement and see that it's in breach of the previous agreements and so on. So talk us through, just before we get on to mediation, then arbitration, what sort of nuclear options might exist for, can I close this company and make a new one? I know it's slightly different to this theme, but this is something that everyone is thinking about.
Yeah, you're right. The nuclear option is always to wind up the company. And there are mechanisms to do that. There are various grounds on which you can seek the winding up of a company, including on it's called a just and equitable ground, which means there's just been a complete falling out. And so the company is no longer operating as it was intended to operate. The difficulty, as you say, with that is not only is there, well, that process for a start needs a court process. So for a start, you're into the courts. Number two, it doesn't deal with all of the pre-existing parts of the company. So take, for example, IP, which can often be very central to startups. What happens to that IP? What happens in a new company that then is established to perhaps run a company similar to that becomes very complicated. If one or other of the two founders sets up a company doing something similar, which in that sort of situation is very typical, is that in breach of either party's covenants in their contracts, things they've signed up to say, I won't compete or I won't compete for X amount of months. So it is it's a nuclear option that needs very careful thinking about before exercising. But as you say, as with all sort of legal remedies, by far the better line to take is, this is what we could do, and this is what would happen. And just going back for a second to the court and that jurisdiction provision for the court, in some ways, having a court jurisdiction clause is great because you say to the party, well, look, if you don't do this, we'll start court proceedings. That will take forever. It will cost you this much. It'll be awful for you. But the trouble is, it's awful for you as well. Much better to be able to say, Actually, if you don't do this, we have a mediation provision, which will mean, you have to come to a mediation, or we have a dispute resolution clause, which will require us to resolve our disputes in a very short amount of time. And I'm right, and then you'll have a decision against you in a very short space of time. And including, I should add, actually, that the winding up process that sort of claim could be heard via a short arbitration. It doesn't have to go through a full court proceeding. So nuclear option is there, but be very careful about exercising it.
Okay, all right, cool. So mediation, what percent of the time do you think it gets a resolution that the parties ultimately agree with? Versus it was great, we spent a time, we understood our rights better, and we didn't agree.
Yeah. If parties go into a mediation voluntarily, either they're not forced into it, which sometimes happens, then the success rates are good. Something like 2/3 of disputes that go into mediation will result either in an agreement on the day or in the time that follows, because the parties have been brought closer together.
Yeah, and I think the mediator explains when it takes them into different rooms why each of them is going to absolutely lose the case. You've got no grounds to stand on. It's terrible. And then tells the other side that. And then both parties go, oh my God, I didn't realize it was so bad for me. I better agree to something halfway. Okay.
Yeah.
So,
yeah, exactly. Yeah.
So mediation on its own, the concept of mediation is non-binding, but you could make it binding by, in the agreement, say that the first port of call is the parties will go to a mediator and accept the outcome. Is that something you can do?
Yeah, so you can provide for a binding arbitration procedure. So mediation will always be a mediator saying, this is what I think you should agree, but the parties ultimately have to agree it. But you can provide for, and I think it should always be the next step, a binding procedure in a quicker time, and which is what Pinq Dr does. So you can provide for a procedure, which means neither party goes to court, but goes through an arbitration process, which is akin to a court process, but much, much quicker. Both parties say, this is why I'm right. They exchange their views as to why they're right or why the other side's wrong. You can have a very short Zoom hearing with an arbitrator, which is a single person, an independent person. And then that person then produces what's called an arbitral award, which is like a judgment, binding in exactly the same way as a judgment, but in a much, much quicker, we're talking months rather than years, and achieves exactly the same outcome, but in a process which is quicker, cheaper, and much less hassle. And the advantage of that is not only the process itself, but if you have a clause like that in your contracts, or indeed a mediation clause or something akin to what I'm talking about in terms of Pinq Dr arbitration, you can say to the party, if you don't do what I'm asking you to do, I can get a remedy in a matter of months. It won't put the company out of business. The other side loses that ability to say, well, there's just sort of nothing you can do about it, really, is there? Because the court will take so long.
Okay, so the mediators and arbitrators are ex-lawyers, ex-judges. What you can find them presumably on your site, but otherwise you look it up online. You Google looking for arbitrator London, something like that.
Yeah, exactly. So arbitrators are almost all lawyers. They may be in practice, or they may have stopped being in private practice and now just be full-time arbitrators. They can be ex-judges. Some of those people will also sit as mediators as well. There's a crossover sometimes between those two sets of people. But essentially, they are neutrals who know something about the relevant law of your dispute. So if it's an English law dispute, typically they'll be an English lawyer. To find them, usually you want to go to a recognized institution or a recognized place to find an arbitrator, because yes, you could search on the internet, but like searching for anything, you might come up with all sorts. But generally speaking, as I say, we've got a list of arbitrators, but also various other institutions have lists of arbitrators.
Okay. All right. So we've got a couple of interesting questions. So the first one is probably more for me, which is, if you have a departed founder, what percent equity is it okay for them to still hold to not be objectionable to later investors. And it's a really difficult one. It's a double-edged sword, because if you're a founder who's put years of your life into a company and ultimately, maybe you're ill, there's no real fault, and you leave and you've got 25% equity, you've really earned that. And, an investor who's put money into the business, the money's been used up long ago. They've still got equity. You've put time into the business. So you don't want to give up your equity. On the other hand, typically, at least in early stage companies, it seems that about 10%, if a departed founder's got more than 10%, and in super early stage, more than 5% equity, that's seen as problematic for a company. It's seen as, dead equity, rightly or wrongly. And I think the real problem is when you've got a company, let's say shares vesting over 3 years, somebody's been there for the first year, not much has happened in the first year, right? So, I mean, if you think about your company over 5 years, in 5 years, maybe you're 100 or 150 people, and you put 5 years of your life into it. And that's the point. It's doing £10 million a year revenue. That's where the value is. But there's someone who's been around for the first year, maybe even not even full time, and they have, let's say, they've kept a third of their 50% equity, so they got 15% equity. Maybe it's been diluted since then. And this is seen as, probably everyone thinks this is unfair and unwanted. And now you as a founder are just personally pained by this other person who still has equity, but you're probably not losing too much sleep about it. You're just annoyed. And then comes a VC and they go, oh, no, you have to get rid of that person and reduce their equity to 5%. And now you're stuck because they are entitled to that. It's quite late in the game. You've got a thriving business. You can't just go, well, shut it down and make a new one. And you've got few options available. And Iain, are there, in fact, any options? What offer can you make to a founder in that case? Or is it really an intractable problem?
Well, I think you're in there isn't an obvious solution. I think it's a solution that you need to try and work out, whether that's between you, as I say, taking the emotion out, finding a solution, or involving a third party to do it. There can be legal claims. It depends on obviously what the agreements say, on what you've agreed. But typically speaking, it is something you need to resolve sort of out. It's not going to be something where, absent the sort of the nuclear option we talked about, it's not going to be something that you can get a neat solution from the courts.
Okay. All right. So the next question we've got, which is not an atypical one, is you've got a founder dispute and you begin writing to you want to resolve it, and you keep writing to the departed founder and they never respond. You want to do resolutions, they don't respond. Sometimes their vote is needed because they've got more than 25% equity, and you need that to waive preemption, and sometimes not. Now the legal agreements may sometimes have provisions that they've lost their voting, or on SeedLegals, we recognize that often investors go AWOL afterwards. They just invested 20K, couldn't be fussed, replying, and consents are needed. So we've got you snooze, you lose provisions, which say if you don't answer or reply within 15 business days, your agreement is deemed given. But what can you do if somebody just never replies? And they may not even reply to a mediation request.
Yeah. So this is a real key area, as you say, where important to put something in your contract, because it makes your life much, much easier. If you haven't got something in your contract, a kind of snooze, you lose provision, then and the party's not responding. And I should add, actually, that's not untypical at all. The types of cases I see are where that is deliberate non-responsiveness because that party wants, for whatever reason, to disrupt the running of the company. There are a few options. Mediation is not going to work there because this is a kind of deliberate non-engagement. Option number one is that you seek an injunction, and that is either a court or an arbitral process, either within Pinq Dr or something akin to it, or in a court. You can seek an order which either requires that person to act, requires them to do what you want them to do, or an order that the court deems that step to have been taken. And we see that a lot. One of the cases I'm doing at the minute is exactly that, where because of stalemate on the board, there is just deliberate non-responsiveness by the other party, and my clients are seeking an order that from a tribunal, arbitral tribunal, that the that party do as they're required to do. Now, again, that goes back to the question of, do you want that from a speedy process which allows you to get on with it, or something that will take a very long time? And that's typically where we think a Pinq Dr clause is very useful, or something like it.
And that's super interesting. And how long would it take to get that court order?
Well, from Pinq Dr, we're talking 6 to 8 weeks. Court, it depends. It depends where you are and in which court. If you're able to persuade the court that you can move, that this is required urgently, with any luck, you're talking again something like a couple of months. And there's usually then a return date, which means you then come back and have a follow-on hearing. Again, don't do it without taking advice, particularly in court. Injunctions in court can involve proceedings. There are specific rules in court. You might see over my shoulder there the white book, which are the court procedure rules. You can see how thick that is. What you don't want that. What you want is a procedure that has very narrow rules, which are simple to understand. If you're going to court, take some advice.
I'm delighted you've got court procedure rules as your Zoom background. I mean, that's not every day. All right. So with arbitration, I'm sure that everyone's thinking, okay, but what if it gives the answer I didn't want? Wouldn't, court thing be better? Take us through that. And then you're agreeing to agree to that. Take us through that process.
Yeah. So whether you go through a court process or a Pinq Dr process, the decision that you get at the end is a binding decision, a final binding decision. There are limited grounds to appeal, both within court and within the Pinq Dr process, but they're very limited. So you are on either way, you are signing up to a process which is final and binding. Now that, in most instances, is what you want. The last thing you want, usually is a process that goes on and on, with opportunities for both parties to say, oh, I'm not happy with that, I want something else. Ordinarily, what you want in these kind of disputes, if you can't reach agreement yourselves, is to say, right, we hand this to a third party, a neutral, and they hear what we've got to say in a fair way, and then make a decision so we can all move on with our lives. And the cases that I've seen where that has not happened, and where there have been multiple levels of appeal, are very unhappy sets of circumstances for everybody. No one wins.
And so how does the arbitration process help with the non-responsive party if they don't pitch up? Does it do something without them, or does it need to wait on them?
It goes ahead without them. The arbitral rules say if one party isn't responsive, the arbitrator can proceed just in a normal way.
All right. And I'm guessing applying for a court order also helps with the non-responsive party, because then they're forced to respond, or they're just going to have something that goes against them, presumably.
Exactly. If you're not there, whether you're in a Pinq Dr process or you're not going to do tremendously well, usually.
Okay. All right. Cool. Now, anything else on the founder side of things? Otherwise, I'll hand over to you to talk about vendor and supplier disputes. What are the most common ones? These ones, I guess with founders, it's a lot more emotional. With vendors and suppliers, it's just business, right? Our widgets didn't work. We want our money back. No, we won't give you the money back. The amounts are probably, often more modest. It's not like you've got a third of my company, bastard. So take us through the most common things there.
Yeah. So the most common issue that you are going to find as a small business, as a startup business, is non-payment of debts. And that is the 99% of the type of disputes you're going to have with suppliers, and indeed with customers. And of course, that can strangle the company. The fact that the cash flow is incredibly important, and non-payment of debts can be massively problematic. Now, In many ways, the advice is similar. Number one, look at the contracts that you have entered into, but perhaps even before that, think about the contracts that you are entering into. Depending on who your counterparty is, you may not have very much bargaining power. And of course, we all completely understand that. Sometimes you've got to sign up to terms which you don't particularly like, but you do it because you want the business. And that might have very long payment terms in them. That can be difficult, but sometimes that's necessary. But try, of course, at that stage to negotiate good payment terms and think again about the dispute resolution clause. If there's something in there, actually look at it. So many people don't even get that far in the contract. It's usually on the back page or so, but it can make such a difference. You want, again, I suggest you want a mediation clause, and then you want something that deals with your dispute quickly. If you simply have a court clause for a startup, it's not going to provide any solution at all, because by the time you've gone through the court proceedings, you're out of business. So look at the contract. Second thing to do is, if you do find that there is a dispute has arisen, let's say you're owed a debt and it hasn't been paid, pick up the phone. And I would suggest doing that rather than trying to engage in lawyers' letters. Don't just immediately instruct a lawyer to send a letter, because as soon as you do that, everybody's guards go up, you get one back, and then you're in a legal process that will take a long time to resolve, inevitably. So really think about how you can, just try and resolve it in a way which is informal and amicable at that stage. Third point, keep a log of all the communications that you have. If you are, for example, I mentioned the phone call. If you have that phone call, once it's finished, then send an email to the others, to your supplier or your customer, saying, this is what we discussed. This is, and this is what I said, this is what you said. It is so important to do that, to have a record, because otherwise, if it does come to a dispute later, it's your word against the other person's word. Really important also, the corollary of that is, don't write anything down that you would not be happy to have read out in open court or in an arbitral process or in a mediation. So don't write vitriolic emails. Keep it very measured, keep it very straightforward, keep it very rational, take the emotion out, explain why you're right. And really important, don't write anything down you wouldn't be happy to have read out in open court.
And this includes internal communications, because they could be obtained under discovery later, right?
Those, and you talked about WhatsApp messages, also WhatsApp messages, text messages, anything, handwritten notes, all of that can ultimately be produced. So do write things down to record what has happened, but bear in mind that it might be read out in open court at a later time.
So that is an excellent thing that I discovered about 20 years ago when I was working with Kazaa, the music file sharing company, and they got sued, and all the emails and so on were obtained under discovery. And there were my emails, sometimes slightly cranky ones, being read out in courts. So since then, every time before you hit send, go, would I be happy with this being read out in court? And if not, don't write that. So,
right.
All right, cool. So, what's apparent here is the value of having mediation arbitration clauses in agreements. I think it's surprisingly infrequent that they're included. Is that the case?
In the types of disputes, in startup disputes or startup situations and contracts and small business contracts, yes. It is unusual and surprisingly unusual. Where you see them is actually in the higher value contracts, where arbitration has become actually more prevalent than court very often. So if you energy contracts and mining and that sort of thing, and big infrastructure projects very typically have arbitration. Often for reasons of confidentiality, because usually the process is confidential, but also because it's more flexible, it's quicker, can be cheaper depending on the process. But for this kind of dispute, I think parties just don't think about it. And if you're a startup and you're entering into an agreement with a new supplier or with a client, the last thing on your mind is, well, what happens if it goes wrong? and so people just don't think about that.
Okay. So whenever at SeedLegals, I get so many contracts that I need to sign, and I always look at two things. What's the maximum upside I get if things go well? But actually, that's not that important to me. The biggest thing I always focus on is what's the downside if things don't work. And, if someone has a contract with a 30-day termination date and the maximum liability is the amount that one of the parties is paid to the other, it's a pretty easy contract to sign. But if it's got warranties and disclosures and directors' personal liabilities, and there's no cap on it, and it's a year contract or a multi-year contract, then suddenly it's a huge thing, and it's going to go to the legal team to review, and much harder to want to sign it. So to me, my colleagues in our marketing team and so on will be focusing on the upside. But whenever I look at a contract, I'm always starting to jump right to the termination clause. What gets me out of this if things don't go well? And what am I up for? And if it's a month's worth of payment on something, or I lose the last month that the other person was going to pay me, it's not the end of the world. But if it's, personal liability and a year's worth of payments, it's like, that's probably not going to happen.
Yeah, I completely agree with that. And in fact, the looking at the clauses, looking at the contract to see what your maximum downside is something that we Pinq Dr offers now to clients to say, actually, we'll look at your contract and say,
okay,
this is your downside risk here. Because I completely agree with that's so important to look at. You have to consider what happens if things go wrong, because sometimes they do.
Okay, so next question. What if one of the parties is not in the UK? That's a European supplier or a US supplier. Does that change things? And also, that was part one. And part two, sometimes your supplier will send you their agreement, which will be, French law, Delaware law, or something like that. How important is it that you get English law and English courts as opposed to someone else's?
Yeah. So in that sort of cross-border contract situation is where actually arbitration, generally speaking, just broadly arbitration has been very popular. And that's for one main reason, which is an arbitral award, including the Pinq Dr award, is what's known as a New York Convention award. And that means it's an award under an international convention called the New York Convention, to which there are 160 state parties. 160 countries around the world have signed up to say that they will enforce an arbitral award as if it were a judgment of their own court. There is no equivalent when it comes to court judgments. There is no equivalent international treaty. And so if you get an English court judgment, for example, there are very few other countries with which the UK has reciprocal treaties for the enforcement of their judgments. And so, in fact, a very well-known arbitrator once said that for international contracts, arbitration is the only game in town. The other reason why it's often chosen is because in the example you gave, if your counterparty is in the US or in France and they say, I want French courts, and you say, I want English courts, both parties have a natural preference for what at least they feel comfortable with. That might be for language reasons, but also because you have a bit, you trust the system, you've grown up with it, whatever. And so there is a natural inclination to go to the national courts, but neither party is happy with that usually. And so arbitration gives you the option to simply say, well, we won't have our dispute resolved either in the UK or in France. We'll have it resolved pursuant to US law and pursuant to an arbitration that's seated in the US. Now that is it's a legal fiction. It means that hearing will be subject to US law, but you can do that hearing anywhere. It could be on a Zoom hearing as we're doing now. It could be in London. It could be in France. And so for that kind of situation, arbitration is actually very common. Now, that doesn't mean it is the answer in every situation that you've posited, because in the French example, the French party may simply say, look, I am not going to supply to you unless you agree to these terms. And it may be you have absolutely no choice in the matter. Startups are often not in a position of great negotiating power if you're dealing with a big counterparty. And you may just have to agree to it and that's that, and hope that nothing happens. If something does happen, take French law advice.
The French company says no. That basically the bigger
Oui.
company is just going to prevail on its choice of law, and there's little you can do other than walking away. All right, so great question, which is what about small claims court? When can you go there? Would that work with a founder dispute? What's the maximum that you can take to small claims court? And can you have anything in the agreement that says, we'll go to a small claims court first?
So the small claims court's jurisdiction in England and Wales is determined by value, and it deals with the smallest value claims that are around about £10,000 and less. You can't provide in your contract that all disputes, irrespective of what they are,
right. Yeah.
That is just court rules, and if you did provide that, the court would just ignore it. The jurisdiction of the small claims court is simply determined by the value of the claim. In some respects, being in the small claims court may be advantageous. It is usually quicker. Having said that, last year the time from issue to decision in the small claims court was 51.2 weeks, i.e. a year.
Yeah.
Not exactly speedy. But the other sort of downside, depending on your view of things, is that where you end up and the decision maker you find yourself in front of in the small claims court is a great uncertainty, because there are many judges of all shapes and sizes, that gives rise to even greater degree of uncertainty than the one we spoke of before. At least if you're in the High Court, you can have a greater degree of certainty as the nature of the judge.
Yeah. On the flip side, if it's a £5,000 dispute, it's not going to kill your business, so you're going to be annoyed. But all right. Now, to wrap up, what advice would you give to anyone on the call when either creating a new contract or having an issue with an existing contract? We may have covered it, but are there like 3 things to do or not to do?
Yeah, there are probably lots more than 3, but let's say the top 3. Number 1, really treat your contract seriously. The temptation, I think, particularly with growing businesses, is to sign whatever comes your way because it's very exciting and you've got new deals, new suppliers, it's all looking rosy. Really read it carefully, because things can come back to bite you, and with particular focus on the dispute resolution provisions, or including focus on those provisions because they really do matter. You want provisions that give you an actual solution that can really help. And generally speaking, just having an English court clause in there for these types of disputes doesn't give you any solution at all. That's point number 1. Point number 2, really important, as we said, keep a note of everything that happens. People don't do that. You'd be amazed. And if you've got a note and have a written record of what has happened in your relationship and where you've got to in conversations, that will be invaluable when it comes to saying why you are right. Documents win cases. And the third point is that whilst you should always take advice, legal advice, when things are looking like they're going to get to court, and no problem to have some legal advice in the background. Generally speaking, it is much better to take out the legal element. Much better to have a frank commercial discussion than to say, I've got this legal right, I've got that legal right, I'm advised X, Y, and Z, because that will just lead to a fallout. It won't lead to a solution. Much better to focus on just the rational reasons why, from a commercial perspective. We talked about debt recovery. I'm a small company. You're not paying me unless you pay me on time. I can't provide you my excellent products that I'm providing you with. Please can we have a discussion and sort that out. That is 9 times out of 10 going to be much more effective than screaming about I've got a nuclear option.
So it's a great point. And I think, to me, the first thing is to understand by looking at the contract what your legal position is, because that's going to then affect, which directions you can pursue and where you're likely to prevail and not. So to understand your position, and then, yes, if you can play on, emotions in the nicest way, particularly with vendors and so on, listen, we can't exist if we don't get paid and so on, is a good starting point, because usually there's a nice party at the other side. So then just to wrap up, coming back to founder fallouts, because it is, I think, at SeedLegals by far the most popular, so to speak, of things, and it's also the most emotional and so on. So, if you are essentially representing the company and you're one of the remaining founders, and there's a founder dispute, bastard, they should lose their shares and we should take them all away. But, I'm not a lawyer, but from what I've seen, company law has evolved over decades or longer to, protect both parties. And seen from the other party's perspective, they don't want to be, and the law protects somebody from a company, a big bad company, just taking their shares away. So things are very rarely easily resolvable. If a person has shares by default, they own those shares and you can't take them away. You could issue more shares and not give them a preemption right, to essentially dilute the hell out of them, as it's spoken about. But then there is this concept of shareholder oppression. So I know that's a deviation from the subject. Anything you can talk about on that, in that sort of checks and balances, and how that might play out? And then it's a wrap.
Yeah, sure. I mean, what you're really touching on there are the minority protections for, or protections for minority shareholders in
Yes.
companies. And the most obvious one is something called an unfair prejudice petition, which means, in the very broadest sense, there has been some conduct which is unfair to you as a minority party in the company. And that might be you're excluded from decision making, that the direction of the company is contrary to your interests, that you're being diluted in a way which is beyond what's reasonable, or that the company is being run in a way which is benefiting the family of your co-founder or something like that. It can also go to extremes like fraud and diverting assets out of the company. And you do have remedies, whether that's in an arbitration or in court, and you shouldn't feel like you haven't. Yeah.
Okay. All right. Thank you. So how can people get in touch with you, Iain?
You can get in touch with me at Pinq Dr. If you want to email me, please do. Iain at pinqdr.com. That's Pinq with a Q.